Hi, everyone. Joe Gentili from Saroff Gentili LLP. So today we're going to talk about if you file a mandamus case in federal court, how does a judge determine whether the delay that you're complaining about is reasonable or unreasonable? And there's no ironclad test that federal courts apply to this, but there is guidance from a case that's very influential. And that case is called Telecommunications Research and Action Center versus the FCC. And in that case, the judge that decided that case laid out factors or guidance that other judges consider when they're deciding whether a delay is reasonable or unreasonable. And those guidance points are known as the TRAC factors, TRAC factors. And there's 6 of them. So factor number 1 is the agency's time to make a decision governed by a rule of reason? So that means, do they have any, do they have a formula? Do they have a strategy for how they're deciding cases, or is it just completely random? So if it's just random, they just grab whichever one's in front of them on their desk, that kind of points towards it being unreasonable. Whereas if they have a structure where, the first one that's filed is the first one they consider, if it's first in, first out, that would lean more towards it being reasonable. Number 2, where Congress has provided a timetable or other indication of the speed with which it expects the agency to proceed in the enabling statute, the statutory scheme may supply content for this rule of reason. So there are some immigration petitions where Congress says that they expect it to be decided within 180 days, or it shall be decided within a certain time period. And there are other immigration petitions where there's really no guidance from Congress as to how long it should take to adjudicate. So obviously the better cases are the ones where Congress lays out expectations or time limits for how long it should take an agency to decide a case. Number 3, delays that might be reasonable in the sphere of economic regulation are less tolerable when human health and welfare are at stake. So this is an important point that we really keep in mind when we're drafting our complaints. A lot of times when we have delays, people lose their jobs, they're in danger of losing their jobs. There's obviously a economic harm that's related to the delay, but we also try to frame these harms in terms of how it impacts their human welfare, all the cascading effects that impact the loss of jobs, or really the loss of the ability to support yourself and your family. So we really go through a lot of effort to try to frame our complaints in such a way that we're saying that the delay is harming the health and welfare of the person that's impacted. Number 4, the court should consider the effect of expediting delayed action on agency activities of a higher or competing priority. So this is a point that the government uses a lot and has successfully used in the past to say that, well, if you filed a mandamus case, we have a line, first in, first out. And judge, if you grant this person a writ of mandamus and you force us to adjudicate their case, all you're really doing is forcing us to put them at the head of the line. It's unfair, and the people who are ahead of them should have a priority over them. So a lot of times the counter argument to this is there really is no line. And from what we've seen, there's a lot of instances where the government claims there's a line and it really doesn't seem to exist, or it's a line that has so many exceptions to it. It's basically Swiss cheese. Number 5, the courts should also take into account the nature and extent of the interest prejudiced by delay. Well, this is pretty similar to the point about human health and welfare. So really, again, this is something we keep in mind to just basically try to argue that the delay is not just annoying, that it's impacting all these different areas of somebody's life. The prejudices are causing real harm. You're losing a job, you're losing the ability to support your family. You can't visit relatives that are elderly. A sponsor or beneficiary, particularly sponsor, has a severe illness, and we need to speed this up so that things are done while the person is still alive or healthy. Sometimes it's a minor in danger of aging out. So this is a point that we really want to drive home with judges. Number 6, the court need not find any impropriety lurking behind agency lassitude, that's a great word, in order to hold that agency action is unreasonably delayed. So this is very helpful for people that bring these cases. What it means in plain English is that we don't have to show that the agency has any bad intent or is intentionally trying to harm people. We just have to look to the other factors. So we don't have to prove that, which would be very difficult to prove. So that's great. So those 6 points are what are known as the TRAC factors. And again, while it's not an ironclad test that all courts must abide by and consider when deciding whether a delay is unreasonable and the court should intervene. But this is guidance that is taken seriously by a lot of courts and is strongly considered. Thanks for watching the video. I hope this was educational and helpful. If you have any questions, please feel free to reach out to me. Thanks. Bye.